Hello, welcome everybody. All right, so we're going to go ahead and get started. Thank you for being here. This is part of the Psychedelic Prior Art Library Porta Sofia's Archival Researcher Network Kickoff event, and I'm really excited today that we're going to have a nice roundtable conversation about Indigenous knowledge and prior art. So, you know, what would it take for Indigenous knowledge to count as prior art, and maybe even backing up, is that something that's actually desirable? And lots of other good questions around that. So I'm going to pass it over to our moderator, Graham Petchnick, and he's going to introduce himself and then kind of take it from there. And if folks could keep your microphones muted during the presentation or during the roundtable, if you do have questions, you can pop them into the chat.
Great, thank you, Amanda, and thank you to Porta Sofia for having organized this panel and this whole event. I know I see some familiar faces here who have been to some of the other events that have happened these last 3 days, and so I think you can appreciate how important some of what's been discussed here. I'm really excited today for what I think is going to be another really important discussion. I'm really delighted to have the opportunity and the honor really to be able to speak with four of whom are I think, some of the strongest voices on this particular topic, and really together, this roundtable I think can really bring forward some really good and deep views on this important issue. So maybe I'll just start by inviting everybody who's on the panel to introduce themselves. Some of you probably need no introduction in front of this audience, but just to provide a short introduction anyways. Maybe I'll start with you, Dr. Tinker, if you could.
Yeah, I'm the odd person out here. I'm not a lawyer guy. I'm a retired emeritus professor of American Indian Studies and have been pressing the issue of worldview difference, American Indian worldview versus the Euro-Christian invasive worldview. And they're distinctly different, and that will impact our conversation, I hope, for the next hour and a half.
Thank you. Yeah, and I'm part of, I think, the importance of having the perspectives of this panel are being able to really see the patent system and see prior art through these different worldviews. I'm excited to be able to discuss that with you. And so maybe we can go to you next, Sutton, if you could introduce yourself too.
Sure. Poso, Segoli, Sutton King, Naktau, Pinuki, Nukat, Sungwa Hawaii, Ni'i, Wagnata, Nawagita Lota, Oniota Aga Ni'i. So hello, relatives. My English name is Sutton King. My Menominee name is Naktau Pinuki. That means comes first woman in Menominee. In my Oneida language, I introduce myself. I share that I am part of the Oneida Nation. I am people of the Standing Stone. I'm Afro-Indigenous, so I come from both the Menominee and Oneida nations of Wisconsin. However, I'm here on unceded Lenape-Hoking land in so-called New York City. I've been here for 10 years. I would really identify as an Indigenous rights activist, a social entrepreneur, and researcher. I also do not wear a lawyer hat at all. I have a master's in public health from NYU School of Global Health with a concentration in global health. A little bit about myself. I've really centered my focus and advocacy on creating innovative solutions to support Indigenous health equity across sectors, whether that's in healthcare, business, or technology, centering really benefit sharing and culturally appropriate methodologies within those spaces. I am the co-founder and president of the Urban Indigenous Collective, which is an Indigenous-led public health organization here in Manhattan. I'm also the co-founder of Shock Talk, which is a telebehavioral application that connects Native users to Indigenous therapists grounded in cultural humility. I was the former Chief Impact Officer of Journey Collab, was a psychedelic drug development company who created a ethical steward ownership model, which I led the development of a irrevocable trust, which took 10% of the equity, put it in a trust to support the conservation of plant medicines, as well as access to mental health resources. I am now the program manager for the Indigenous Medicine Conservation Fund, which is a high impact Indigenous-led fund supporting the survival of 5 keystone medicines, that being ayahuasca, iboga, toad, peyote, and mushrooms, and really ensuring that our Indigenous peoples are leading our conservation programming, and really ensuring that there is a vehicle for access and benefit sharing where the psychedelic space is, coming into a lot of wealth. We need to ensure that our plant medicines, our Indigenous peoples are supported and are at the forefront of this so-called psychedelic renaissance. Thank you for having me. Really excited to be here. I definitely am not an expert in patents, but as an Indigenous voice, it is always an honor to share my perspective. So thank you, Makwain and Yako.
Thank you, Sutton, and thank you for bringing your voice to this conversation. Preeti, can I pass it to you for your introduction?
Sure. I'm Preeti Krishtel. I'm the co-founder of the Initiative for Medicines Access and Knowledge, or IMAC. I don't know if everyone was here yesterday, but I shared my whole trajectory over the last 20 years. So I will keep this short just to say that I've spent the better part of the last 2 decades working all over the world alongside communities to think about how we democratize patent systems, how we make patent information more accessible, how we challenge when the patent system is being misused or abused, and how we raise really central and fundamental questions to the idea of ownership or possession, especially for things that have the ability to impact human life like medicines. So thanks for having me.
Thank you. And David.
Yes, hello, David Casimir. My areas of expertise, sort of traditionally academically, are I was a scientist originally. I'm a PhD biochemist. I left science for the law, although I like to consider that I'm sort of living in both worlds. Became a lawyer, and my legal practice expertise is in the area of patent law primarily, although I do work in copyrights and trademarks as well. I work with all different types of clients, mostly in the healthcare space. I have a good expertise with the mindsets of individual inventors, academic researchers, big pharma, startup companies, and everyone in between. Kind of relevant to the topics we're going to be talking about today, I'm one of the co-founders of Porta Sofia, an organization, nonprofit organization created with the recognition that there was clearly a land grab being made in the pharmaceutical healthcare space, and that much of that land grab was involving patents and patent applications that were unduly broad and should never have been granted or should not have been filed in the form they were filed, and creating resources for the world to minimize the chance that overly broad patents will be granted or maintained in a way that will reduce access to important healthcare resources for everyone in the world.
Great, thank you, David. I guess I'm last. I may have forgotten to introduce myself, but just very quickly then. So my name is Grant Pachenik. I'm also a patent lawyer. I have a firm called Calyx Law, where I've been very interested in finding ways to sort of balance the tension of the work I do, which is generally working with clients to file patents, with the controversies around how patents are used in this space and the way that they can, if they're used improperly, create issues for access to psychedelics. And I'm in San Francisco, which is Ohlone territory, and I'm really excited, I guess, to get this conversation started, I think conversations, but maybe just to sort of reorient ourselves to the extent we need, just to the patent system itself. Maybe if I could start with you, Preeti, to just sort of broadly just give us an explanation, I guess, from the perspective of somebody who's a patent lawyer yourself and has worked in the patent space, who familiar with intellectual property in the patent system, just to describe the intellectual property, I suppose, itself, just as a kind of a system concept, and how patents and the patent system work as part of that.
Are we losing Graham?
Yeah, it sounds like you're breaking up a bit, Graham.
Okay, just to make sure it's not my Wi-Fi.
Oh, sorry about that. I'm not sure if you caught my question, but just to orient us to intellectual property, patents, and just generally the patent system.
Yeah, no, definitely. But first, I feel like I have to disclaimer that I'm not a patent lawyer.
Oh, yeah.
I did go to law school, but I consider myself an advocate for a more equitable patent system. So the way to think about IP, I think David was just saying, we know the concepts, right, in popular society: copyright, patents, trademarks, trade secrets. Pinning down a definition of intellectual property can be a little bit harder, but the way it's commonly defined or understood is as an intangible asset, right? It's not physical in nature. Some people describe it as a creation of the mind. Whether it's an invention or it's an artistic work, it's something that the law protects from unauthorized use by other people. And so when we think about patents, these are supposed to be a time-limited monopoly that are given as a reward for inventions to motivate people to invent things. And that vision of patents has really, what we believe is that vision of patents has really been eroded over time. Over time, there has been a sharp rise in the proliferation of patents. In the first 155 years, for example, since the US Patent Office was set up, there were 5 million patents that were granted. And then over a 27-year period after that, another 5 million were granted. So we're sort of living in an era in the last 40 years where there's just been a really sharp uptick in patenting, where it's become more of a legal strategy and a business strategy to stockpile patents. And so that original intention has been eroded.
Yeah, thank you for that. And so maybe just to set up the conversation at a very high level, I think one of the things you mentioned in your introduction was talking about the different worldviews. And so, I've heard you talk before how in Indigenous worldviews, there's no notion of property or private pieces of property. And in fact, not even words for property in Native American languages. And so obviously here today, we're talking about intellectual property and property through, what you've called the sort of Euro-Christian worldview. So I wonder, maybe we can, before we kind of dive into intellectual property and how intellectual property is used sort of as part of the patent system, just to get your perspectives on just property generally, and sort of if you have reflections on intellectual property in particular from an Indigenous perspective.
That's actually a very complex question that summons up 500 years of colonizing history and Euro-Christian invasion of the Americas. And that makes things more complex because Indian people end up then walking our own worldview, but having to navigate equally well in the Euro-Christian worldview. Our languages, and I should have said Blinde Wajaju Tsele, that I'm a citizen of the Osage Nation. Our languages tend to be verbal languages and not noun-based. Euro-Christian languages are entirely noun-based. And you can see it particularly, for instance, in German, where they capitalize every single stinking noun to make sure you know nouns are important. For us, it's the verbal action, the concrete. Nouns, on the other hand, are very prone to abstraction and gives rise to whole fields of discourse like law. Just as one example, because all of your Christian world is embedded in deep abstraction of one kind or another. Property is one of those words that is entirely abstract. What is a piece of property? Well, I've argued in other settings that the first Euro-Christians to invade the Americas did one thing before anything else, and that was to convert not the people to their religion, but one person, our grandmother, the land, into this category they call property, so that she could be sliced up into small parcels and sold as private holdings to individual European invaders. We never had that. We don't even have words that reflect that kind of thingification of people, the thingification of the land. So I have a ranch. It is outside of Denver. We don't have that word "it" in any of our languages. Pronouns in Osage are e, I, ita. He, her, and theirs. In other words, they're not marked for gender or for number, either one, but they're personal. None of them reflect the Euro-Christian category of neuter. That's an unknown to us. So that when we talk about the propertyization of the land, or propertyization of anyone, or the propertyization of ideas, of intellectual thought, it's absolutely foreign to Native people on this continent. There is no knowledge that I have of my people that belongs inherently to me that I can negotiate to sell to any one of you, because that knowledge does not belong to me. It belongs to the people. And it's not enough to get a leader, because we don't even have leaders in traditional culture, to say, okay, I authorize the transmittal of this knowledge to your white library or white collective intelligence. To the contrary, you have to do what the Mayas, the Lacandon Mayas, told the Mexican government 30 years ago, when the Mexican government tried to settle the uprising of Lacandon Mayas in Chiapas, Mexico, offered them a deal and told them, we need to have an answer in 24 hours. And the Maya delegation said, we can't tell you in 24 hours. We have to travel back to Chiapas, hike back into every village, explain the deal to every person in the village, and get everyone's agreement. We'll be back in 6 months. That's what I meant before we came on air, Graham, by saying we're playing a different ball game than you are, by different rules in a different ballpark. And now we're being forced, and have been for 500 plus years, to play our ball game by your rules. So we've got to find a way now to make our knowledge of the world fit into your structure of abstract ideas like prior art, and settle for whatever we can get from that as Indigenous people in order to live peaceably in some sort of harmony with our abuser. That's problematic. It's problematic, as you can read in the news every day, as we discover more and more unmarked graves at old child incarceration facilities that you all euphemistically call boarding schools, which had nothing ever to do with education, but only merely with separating children from their cultures so that they could be brought into that Euro-Christian worldview and learn to speak English and not their native languages. So maybe I'll pull up here and I'll have more to say as the conversation continues, but that gives us a notion of the Indian perspective on all of this. And I'll respond to any questions I may have generated.
Yeah, thank you for that. I mean, and that makes me realize that we are, I think, now moving back into what probably will feel like a very different playing field.
You're still breaking up on us,
back to the sort of patent question. I'm sorry about that. So maybe I'll just switch to a question then, which for David, coming back to the playing field of patents and I guess the thingification of them, maybe we can just sort of go through quickly. I know you've talked about this before with some of your other talks here, but just for folks to get us oriented, just what it is that makes a patent or an invention patentable, and just what is prior art on the patent system, and what is the role of prior art in determining whether inventions are patentable, and how it plays a role in the examination of a patent application.
Sure. So let me start with a quick introduction of what can be patented and what that process looks like. And just so everyone's aware, I should probably mention the process first. If someone thinks they have an innovation that they want a patent on, what they're asking for is a government agency to acknowledge their invention and then to give them a certain set of rights because of that. So the process involves a communication with a government agency. And that takes the form of documenting your invention and submitting it to that agency for their review. That review, at least in the United States and in many other countries, looks at several criteria to determine whether you can get a patent on a thing. The first criteria is it a category of thing that can be patented? And there's a specific list in each country that has a patent system of what counts and what doesn't count. And sometimes the boundaries of that change, but it's broader than most people think. It's essentially most things and most processes. So just to give some examples, the board game Monopoly, if people have played that, was patented as a process for moving pieces around a board and collecting rents. And I call that out because it's a specific property-based invention at multiple levels. A 7-year-old child from Minnesota obtained a patent on a method for swinging on a swing, where you pull on the chains to move side to side rather than backwards and forwards. It was an embarrassment to the patent office because they granted it. That's actually not something that child had created. Every child has probably done that in their childhood. But people are shocked by how many things can be patented. The category is very broad. As long as you're in one of those categories, then you essentially need to meet 3 other major criteria. There's some minor ones as well, but the invention has to be new, which means no one before the inventor had done that thing, or at least done it publicly. If someone secretly did it and no one knows about it, someone could later on do the same thing and potentially get a patent on it. But if there was public knowledge of the thing occurring before, it's not new and no patent can be granted. The next criteria is it has to be non-obvious. So even if it was new, if it's a variation of what came before that people in the field would appreciate as something that someone should have thought of, you cannot get a patent on it. And then the last major criteria is called enablement. It's the big trade-off. You get a patent from the government if you invent something, but also if you share the details of what you did. So you have to be able to disclose in the patent document the recipe for how to make and use that invention in such a way that others can read what you did and based on other knowledge out there in the field, get it to work. So you can't hide your idea and still get a patent on it. If you clear those criteria, you get a patent on anything that clears those criteria. And it is a wide range of things. And ultimately, one person typically in the patent office is the reviewer who determines whether someone clears those criteria or not. Graham, I've been chatting a bit. Did that address everything, or was there a second question in there?
Well, I think the second question, although maybe if my internet cut out, I missed it, was really just about what prior art is.
I'm yes, sure I should define that. Yeah.
Yeah, I think at a high level, just describe prior art and really why is it important in this process and how is it used in patent examination? Yeah,
so I mentioned two of the critical criteria are that the invention's novel and non-obvious. And so what prior art is, it's a weird term, and it's actually got historical roots. It's a term that comes from the 1700s, ultimately in the United States in terms of, but it's what it's referring to as evidence that a thing was not new or that a thing was obvious before someone filed a patent application on a particular innovation. And so prior art is essentially the collective term for all things that the government counts as evidence that can be used to demonstrate that something's not new. And so common categories are things like publications, books, public presentations. If there was any commercial activity in the past, if products were being sold, that counts. But it doesn't have to be, physically documented things. It can be some of the categories of prior art are is if something was publicly known or used. Now, sometimes it's hard to prove that, but if you can prove it, the public knowledge or the public use of something in the past prevents someone, in theory, from getting a patent on it in the future.
And maybe to stick with prior art, I mean, I've heard you use this term a couple of times, that there's this huge knowledge gap or this distance between what's available, I suppose, to an examiner and what prior art is sort of out there under these kind of abstract definitions, like you mentioned. I mean, maybe if you could describe that, and is that particularly a problem in the psychedelic space?
Yeah, and it really gets to the heart of, I think, the discussion we're having here today. So what counts as prior art? How accessible does it have to become public is oftentimes a big question. And the answer to that is something counts as prior art if a person in the field of the invention could publicly get access to it. So there are things that are prior art that have maybe never been seen by anyone or by no one other than their creator, but it still counts as prior art if it's accessible. Now, that doesn't mean the patent office will ever find it, right? So if there's a PhD thesis defense in writing in the basement of a library in Japan, and that's accessible to the public. It's not easy necessarily to get it. It might not be in any electronic databases or searchable. It counts as prior art because it's accessible, even though it's not easily accessible. So prior art is this broad range of things that are accessible to the person skilled in the field. We run into the problem, though, that the patent reviewer won't find that PhD thesis in the basement in Japan if it's not in an electronic catalog. The patent reviewers are given very little time to do their review, and they typically use, they have a set of internal databases at the patent office, but then they typically use peer-reviewed literature databases and patent databases to find the prior art. In the psychedelic space, a lot of the knowledge doesn't exist in those traditional areas for obvious reasons based on the history of these compounds. And so there's a big knowledge gap, particularly in the psychedelic space where the knowledge is out there, and technically it probably legally counts as prior art. It's just not easy to find. So getting it found becomes the challenge. And that's one of the reasons Porta Sophia was created, was to gather it and make it easy for the patent offices to find. And I'll just note, related to our discussion here, especially when we talk about indigenous knowledge, this idea of something being publicly accessible when someone skilled in the field can find it becomes a really interesting question, because who is that person? Is indigenous knowledge in certain circumstances accessible to that person if they're defined a certain way? The answer may be no. If they're defined a different way, the answer may be yes. So a lot of what counts as prior art when it comes to indigenous knowledge is going to come down to a definitional issue about who is this skilled person and what information did they and do they have access to.
Yeah, and so a lot of this maybe still feels fairly abstract. And so I really enjoyed, Preeti, your keynote yesterday. I think when you were able to really humanize a lot of what these sort of issues with bad patents and overbroad patents mean for people. And so maybe this is a kind of good place to pause. And besides just sort of talking about in an abstract way how prior art should be found and is important for patents being granted and might cause overbroad patents to issue if it's not in front of an examiner. What does it mean when there are overbroad patents, and what are the impacts of these bad patents? And how have you seen that? And I guess I should apologize for having labeled you a patent lawyer, but I've heard you speak on patents so many times. I guess your fluency in it tricked me, but point noted. But I guess from your perspective and in your decades of work around patent law and around patents, sort of how have you seen this play out?
Yeah, and I should say I'm not a patent lawyer, and I actually think that's important because I think many of us actually need to become equipped, like the things David is teaching us from a lawyer's perspective. It affects everyone's lives. It affects, as we're hearing today, the lives and the traditions and the practices of communities. And so I think it's really important that people who are not patent attorneys be able to speak on these things and understand them and navigate them. So when David was speaking, the thing that was coming up for me was in the early 2000s, at the peak of the HIV crisis, there was a drug. The company that's now called AbbVie used to be called Abbott Labs. Abbott Labs had a drug that was a combination of two different HIV products. And together, those two drugs put into one combination were called Coletra. Now, Doctors Without Borders spent those early years, maybe from early 2000s to 2005, writing to AbbVie and saying, we need a version of this drug that we can get to rural parts of the global South because there's not AC, there's not refrigeration. We need a version of this drug that's heat stable. And over time, sorry, the patent issues on this are complex. The simple version of this story is that Abbott did develop a heat stable version of the drug, which meant that it could then go out to the most rural parts across, Asia, Latin America, and different parts of the African continent. But they would not partner with any companies in the global South to expand production and actually make sure all the communities who needed them would get the drug. So we decided in India to challenge the patents legally on the heat stable version of the drug because people just weren't getting what they needed. And so we did exactly what David was talking about. We started to go through all of the published material around this HIV drug. We read patents, we read scientific publications, we reviewed presentations that drug companies had made at conferences. And finally, we found what we call like the killer prior art, which was, it was like a marketing piece of material where Abbott had said, we're gonna buy this part of the German company BASF's product line where we can purchase something called, this is many years ago, I hope I'm getting the facts right. We're gonna purchase something called Meltrex. It's melt extrusion technology that can be applied to drugs to make them heat stable. And when we purchase it, we'll be able to make our HIV drug heat stable, and then we'll get another patent. So we were like, cha-ching, because part of what the patent law says is that it has to be non-obvious. It essentially has to be inventive. The word surprising is used in the law. And here they were basically saying, we know that this can work on our drug. That's why we're buying it. So we submitted that as part of, many, many pieces of prior art or evidence in the case. And the patent office in India agreed with us that this actually was obvious and shouldn't get a patent. And so it took 8 years, but we won that case. And generics in the meantime were able to enter and produce the heat stable version. Groups like the WHO and the Clinton Foundation were then able to expand production of the heat stable version of the drug, and millions more people were able to get it. And so prior art is like a technical wonky concept, but it can have this really powerful impact of opening up access for a lot more people. Oops, I think Graham first.
Thank you. So maybe before we discuss how we can think about integrating Indigenous knowledge as part of, start just with maybe a definition of even what Indigenous knowledge is, or how we can approach a definition. Maybe Sutton, can I ask that question to you? Is there a way that you'd be able even to put a definition around this? Is that something that's hard to even sort of encapsulate in a single definition? Or I know our panel is Indigenous knowledge and prior art. We're thinking about what would be the types of Indigenous knowledge used as prior art. How can we even sort of draw boundaries around what we're considering as, you know, part of this discussion?
Yeah, I think that's a really difficult question to ask, knowing that Indigenous peoples, we're not a monolith. So our knowledge varies, our ways of being and perspectives vary a lot. And so I think, that's really hard to encapsulate in a single definition. It really depends on the Indigenous community in which you're sitting with, their history, their ways, their belief systems, which again can vary from tribe to nation to person. But just sitting here and listening to everyone speak, it was interesting to me because I heard in the beginning the words of like ownership and stockpiling and land grab. And, these are the issues that we see that continue to perpetuate throughout our generations, right? From the time of settler colonialism. And it's just interesting for me, again, I don't have any expertise in patents, but, what I can share is just a personal story and my own experience. And so I come from the last chiefs of my tribe. My grandfathers were Chief Oshkosh Braveheart, if you are familiar with Oshkosh, Wisconsin. And my grandfather was able to do something that was pretty rare at the time, where he understood that our language and ways of life were changing. We didn't understand, like Dr. Tinker said, this concept of land ownership. How can you own something that we're stewards of? When we think about kinship, we think of being interconnectedness of all things, inanimate and animate, right? All of the things of our relatives, including the plants, the plant medicines, our four-legged relatives, our two-legged relatives, our winged relatives. But he understood that the times were changing. And so to ensure that we weren't forcibly relocated and removed where many tribes in the United States are, he was able to barter with the United States government and really walk in these two worlds, something that I commonly feel like I have to do, especially in this psychedelic space. And by doing so, he had to cede over 3 million acres of our land so that we could have today 200,000 acres where our creation story started, because he really understood the importance of our land, our medicine, our culture, our trees, right? We have one of the most dense forests in the Midwest, and that was through his teachings of sustainable forestry. But these are just not the concepts in which, the Western world thinks of. It's very much so individualistic, it's very reductionist, and it's not about being a good relative to, everyone within the kinship circle. So I think about that, and I think about how he had to navigate that world and how inherently traumatic it was for him to do that. Although he has this great legacy of what he was able to do for, my nation and my people, my family, unfortunately he died, in a violent brawl, due to his substance abuse disorders, right? Which were introduced to our communities to be able to take from us, right? And so it's interesting when we think about just these words in which we're using these concepts that are not our ways, our traditional ways. And, you know, like Dr. Tinker said, we're forced to have to exist within this paradigm that doesn't fit. It's like putting a triangle in a square peg, right? But we're forced, and it's hard. It's very difficult for us. And so I think it's interesting right now where we talk about, you know, prior art, and, you know, it's hard to find, it's hard to count. It really reminds me of a lot of the advocacy that I do here in New York City, where time and time again, I'm told that the data, the research, is too hard to count us. So there's no disaggregated data we're put into other. It's just too difficult, so we don't do it. Or what I hear is you're not important enough for us to do it, right? Which makes it very difficult for us to organize, advocate, right? Because what's happening is this like data erasure, right? Data terrorism. What I'm seeing is the erasure of our history, the erasure of our ways of being and knowing, that's being told that they're not valid, which they are valid, right? And so when we really start to center Indigenous voices, our ways of being as valid, we'll really understand that I think we have a lot of these concepts all wrong. How can we own something? How can we patent these plant medicines? The only owner of these plant medicines is Mother Earth. That is the owner of these medicines. And so I think it's really hard and difficult to answer that question on exactly what Indigenous knowledge is. I think it, again, can vary from perspective to tribe to nation, but just wanted to share, you know, listening to Dr. Tinker, definitely feeling in deep alliance with the way in which he shared his experience and knowledge. So thank you for that, Doctor.
Yeah, thank you. And maybe Dr. Tinker, I can ask you if you have any other further reflections on sort of trying to grapple with a meaning, if a meaning can be found for what Indigenous knowledge is, or at least I suppose for purposes of sort of clarifying it for the discussion today, if we can.
Sutton, thank you for that statement. It's very nicely put. I want to say one thing clearly that may advance our conversation substantially. That is, Indigenous knowledge is another Euro-Christian abstraction that has no real actual existence in any Indigenous community. We do not have Indigenous knowledge. I know that sounds outrageous because y'all live with that as an everyday notion. It's a part of your worldview. Of course you have knowledge. And in fact, my wife created a course that she and I taught 20 years ago titled Indigenous Knowledge and Euro-Western Science, in which we argued our ways of knowing are the equal of Euro-Western science, as powerful, David, as your world of the sciences is. We also have a knowledge base of how the world works. But to call it Indigenous knowledge is to categorize it, you know, to thingify it in such a way that now it's a negotiable commodity. It's like a water conservationist magazine interviewed me a year ago and were surprised to discover I did not profess to be a water conservationist. And he asked me with an incredulous tone, why? And I said, to be a water conservationist, I have to commodify my grandfather, Wajaji. I have to put a price on him, whether it's the plastic bottle or an acre foot. We live rather in relationship with those relatives, not in some thingifying abstraction that reduces our close relatives to its, to things that can be, you can put a price on. And the same is true of this category you all call Indigenous knowledge. that's what I meant by saying we're really in different ball games, trying to speak to one another from ballparks that are several miles apart in different parts of the city, playing by different rules. And whether we do that by text messaging or email, you know, we've got to sort out what your rules are before we can play. You all don't have to sort out what our rules are. And that's a problem. Because you all won the war. You all invaded and conquered. You all created those, the euphemism is boarding schools, Indian child incarceration facilities, in order to make sure that the next generation of Indians thought like white people instead of like our own people. And we're still in recovery from that. So I guess I want to say there's no such thing as indigenous knowledge. It's like saying Native American spirituality is a Euro-Christian invention. We don't have that. Namely, we're thoroughgoing materialists if we get down and dirty about it. So there are no such things as spirits, even though we use that word commonly in English. One spirit came to us in a ceremony, and the Eshka, the interpreter who was running that ceremony, said, "This spirit weighs 300 pounds. He's only 4 feet tall." Well, you can see immediately we're not talking about spirit in the white Euro-Christian sense, because these spirits have physical bodies. One other analogy I'll give you is, you know, this in world religions, we teach about the Hindu religion. The Hindu religion was invented in the 1890s by British academics at the University of London. It has no existence outside of the university. And the same is true of American Indian ceremonies and what we do. There's no such thing as American Indian religion or American Indian spirituality. We have a way of being in the world, a way of living. It's all verb-based. It makes it very, very different and very hard for us to talk about what we do and make sense to y'all in terms of what you do and how y'all live life. That's what I mean by worldview difference. And, you know, I've got a colleague online with us right now who is co-authoring a book with me on worldview. So there's much more to be said about that than I can say in this brief talk. Kaushikato.
Thank you for sharing those thoughts. And I think recognition that I'll be shifting games a little bit back again, but and recognizing that, you know, there's not an easy way or even a way at all to use this definition, sort of sticking with it anyways. And David, you've talked about the just psychedelic prior art. If we were to try to think about a knowledge gap with regard to indigenous prior art and indigenous knowledge, obviously we have the knowledge gap that comes from the inability even to properly define it. But using the sort of definitions available to you from, I guess, worldview, you know, what are the particular problems with sort of using indigenous prior art, or even how patent examination or the patent system in general, that maybe it's also not available, or maybe there's a similar knowledge gap? How does that play out?
Yeah, and so Dr. Ticker's discussion was actually really interesting, and I'm going to, I think, come back to it at the end because it may play a role in how the U.S. legal system would view some types of knowledge that are boundary cases that might be a basis for legal dispute. But I'll come back to that. So when we're talking specifically about adjudicating in a US legal system whether a particular patent claim is patentable or not, or valid or not, there is a roughly well-defined structure that dictates how one goes about that process. And so let me take an example, an easy to envision example that I think the courts would find and the patent office would find very acceptable and easy to address. And then we'll take a more challenging issue that might be what someone would call indigenous knowledge as a second example. So one of the categories that the law in the United States accepts as prior art is public use of an invention. So let's assume that someone had filed a patent application today that covered the idea of using peyote or mescaline for the treatment of depression, right? So patent law is about words and definitions, and many of them are nouns. In fact, I don't know that it'd be very challenging to write a valid patent claim under US law without nouns. But so let's say that claim's out there, right? So now we know that's not new. People have treated depression with mescaline for thousands of years. But let's say someone files that claim. And thankfully there is peer-reviewed literature that would knock that out today. But let's assume there wasn't. Let's say there's a case where there isn't sort of traditional prior art that's findable. But now if we had a YouTube video that was produced a year ago with someone capturing their friend in an interview, saying that they are treating their depression with mescaline, and then on camera doing that in the public square with lots of people milling around and watching it, that would almost certainly be sufficient evidence for a patent reviewer, if they saw that YouTube video, to say, this is prior art. This was public use. This was done in a public square. And I have evidence of it in that it was captured in this electronic format with a date on it that is reasonably trustable. And if we really need to push the issue, we can get a subpoena and get access to YouTube's records to confirm it, right? Like if there's a big legal dispute, you'd get into that level of detail. So that would be a public use of that invention that would prevent its patentability. Now let's take that situation to someone 500 years ago in the American Southwest who was using peyote to treat what modern people would call depression. That term wouldn't have been used at that point in time and maybe not even be recognized in that capacity. But if modern scientists would recognize that that person had that condition under modern medical definitions and used peyote and received relief for that condition, and that was done in a public forum where the community saw it and knew about it, that also is prior art. It was a public use of the invention. The question from a legal standpoint in the US is there evidence of that? Because prior art doesn't count just by its existence in the universe where, by magic, we could re-envision everything that's ever happened anywhere. It has to be shown by evidence. And so the evidence of that becomes a lot trickier because of time, cultural, language, and a lot of other differences, right? And so even in situations where we might have a record or a witness that we could talk to, so not 500 years ago, but say 50 years ago, or 20 years ago, or 1 year ago, then it becomes a question of, is that evidence good enough? And when we get into cultural differences and differences in how we use language and how we understand concepts, it's a more challenging situation than the YouTube video done in, say, a traditional Western conversation. Because if you really interrogated that, the witness who has that knowledge that in theory could be prior art may not be articulating it or evidencing it in a way that a Western legal system would treat the same. It may not, but it'd be one of those areas that if it were in court, with two multi-million-dollar parties expending all of their resources and using expensive, talented attorneys fighting on the issue, they're going to battle that at every little point of minutia, and it's going to be a challenge. And so I don't know if that's the best example, but that's sort of the off the top of my head example of those distinctions and challenges that might come into play.
Yeah, thank you. You've mentioned that there may be some areas for incorporating sort of alternative forms of prior art that may include these types of, I guess, verbal recordings of spoken conversations or other things as prior art. And I think you've even mentioned before about part of the patent in 2011 that covered kind of a catch-all for different types of prior art. Just as sort of what the legal bases might be, is that one of them? Are there changes in the law that would need to be made? Is there anything about how the patent system or the patent law is structured now that might not recognize certain types of indigenous knowledge as sort of prior art?
Yeah, so good questions. So the law, at least in the United States, really, well, I guess it comes from three big areas. There's the statutory law. That's the law that Congress passes, and they've passed patent laws. And they actually just updated the patent law in the United States in the year 2011 in some fundamental ways. And one of them was they added some language that in theory opened up and expanded what counts as prior art. Under the old law that was written in the 1950s, the categories were much more distinct. The 2011 law essentially introduced some language that's open-ended that said something to the effect of, or otherwise was publicly known. So all of these specific categories or other information that was otherwise publicly known. So it opened the door for things that might not have counted as prior art prior to 2011 counting. Now, it's relatively new law from the time frame of how courts work. Lawsuits are long and expensive. So that hasn't been tested much yet to date. But that leaves open a window for types of prior art that might not have traditionally counted as prior art to now count under the US legal system. The last major area of where law comes from is courts. And anyone who's been in court or followed court decisions is really familiar with how you'll have this law that's written by Congress that can be interpreted multiple ways. And then over the years, the courts interpret it and interpret it and interpret it, and it evolves in sometimes some very extreme ways. And that's also true in patent law. So ultimately, it will probably be the courts and court decisions addressing conflicts in individual cases that will set those definitions of what counts and what doesn't, and it'll move over time, and it will act like a pendulum. It'll shift in one direction and then shift in the other, and then maybe eventually find its way to some point of equilibrium where the law will be at least a little bit more concrete and understandable. But in terms of the changes in the law that happened recently, I don't think we're anywhere near that. And I'll say in general, what counts as prior art from however it's defined, the category of indigenous knowledge hasn't been well tested, and largely because it hasn't needed to have been well tested, because there are typically peer-reviewed literature or other easier to find, easier to fit within the law sources of prior art that have worked for most types of cases. The psychedelic industry introduces a new paradigm, though, and probably more than anything I've seen in a long time and maybe ever, where indigenous knowledge might have a bigger role than it does elsewhere, and where these boundary cases in the law might actually get tested. But maybe not. There might be sufficient knowledge without accessing indigenous knowledge or invading into indigenous knowledge to do what needs to be done to block the bad patents. And I think that's a big question, and it's a patent by patent issue. But I think part of this conversation, it's important to figure out if that, however one's going to define that knowledge, what invasion does it play to use that knowledge? Is the balance of benefits and harms to the various stake players whose well-being is at stake play out where it makes sense to access it? is it, and I know access is a trigger word I'm imagining for people from now to Western culture, because that also has a big territorial aspect to it. But is it needed? If not, it probably shouldn't be used. For both legal reasons, it's going to be harder to use it, and from invasion reasons. And so I guess there are questions about whether it's needed, and if it is needed, what is the appropriate way and the ethical way and the moral way to cooperate, if cooperation is available, to happen to make that information available in a way that the stakeholders who have that information get their say in if and how it's used, and have a position to gain a benefit if they choose to, if there's one to be had in the use of it. And I think those are all really tricky, challenging issues.
Yeah, there's some really big questions you asked, and hopefully we'll get to some of those in our remaining time here. I want to make sure I also leave time for questions. Say people can also post questions in the chat if they have them, and I can try to ask them as I go along here. I turned my video off because it sounded like I was breaking up, so hopefully I won't be breaking up anymore. Maybe before we move on to some of those questions, Preeti, I know you've spent many years challenging bad patents using prior art. I wonder if you have any sort of reflections before I move on whether this type of prior art would have been the kind of prior art that you could have seen using, or if you see issues in how it can be used to challenge patents that maybe are things we could raise.
Yeah, I'm really sitting with what Tink and Sutton have been talking about right now around just even the notion of property itself, like how infrequent it is, in American culture and society, that we even like pause to be contemplative about, like, why do we accept these notions of property to begin with? I don't have actually a lot to offer your question, Graham, except to say that, I've watched from a distance as groups. I remember back in the early 2000s, there was a group, I think it was Natural Justice in South Africa. There were community-led interventions in India and Brazil, challenging cases at the European Patent Office and the USPTO, where traditional knowledge was companies were attempting to patent it. And those interventions, I think, were mostly successful because they were able to show that this is not something that the company came up with. People had already known or used these ideas or these products for a long time. And there was one other thing. So I think that for me, it always goes back to, who is able to speak to what should be done, and then where are they being heard. And the nice thing that I remember in some of those situations, there were also some agricultural cases in this regard in India back then as well. It was like, and it was, we were talking about this yesterday, for the first time, the farmers went to the Indian Patent Office, or for the first time, the community group in Brazil was being heard at the European Patent Office. So there was sort of this transnational element too, where there were catalysts and intermediary advocates who were helping to like build those bridges and figure it out. But it still is very much within the Western legal framework of, who has the power to actually decide who gets to use it, who gets to make money off of it. And when countries don't, also join these international frameworks, then it's also left to like the ethical imperative of individual investors, companies, and all of the stakeholders who are participating in the action. So I think that's really interesting in this moment too, about what this community is grappling with, is how do you sort of go against these prevailing systems and norms, or even language, as Tink was saying. I think there's a lot to grapple with here.
Yeah, there definitely is a lot to grapple with. Maybe a first place to go to grapple with something is, one of the questions you left off with, David, just about the sort of ethics generally of how you would go about gathering Indigenous prior art and who has the right to speak to it. And Dr. Tinker, you talked about the nominalization or thingification of things and how these aren't really fitting in with the Indigenous worldview. And of course, I guess to some degree, it is a thingification of knowledge to turn it into what's quote unquote prior art to be used by patent examiners of the patent system. So I wonder your perspectives from an Indigenous viewpoint, acting as prior art, or do you see a way of doing that ethically or doing it in a way that balances the hopes that people have for using that knowledge in a positive way with what the harms could be, I suppose, if there are any.
Yeah, there's also a question in the chat box that relates to this. Is there a separate model, a legal model that could include a new class of patents for Indigenous knowledge, which grants Indigenous people rights to ownership or licensing and control of them? See, that's our conundrum. Every time we run into a problem with colonization in terms of slowing down extractive industries, whether the extractive industry is oil and gas or Rio Tinto zinc mining $100+ billion worth of copper out of a mountain in Arizona, or whether it's our medicines, ayahuasca, for instance, that's extraction. And it's part of the Euro-Christian extractive industries. We're told you have recourse, go to court. And we have here in the Denver area, up in Boulder, a big organization called Native American Rights Fund that works with Indian nations across the continent to represent them in those courts. But why should we have to go to your courts in order to secure our freedom to act, or to use another abstraction, to secure our rights, which, when I use that abstraction, rights, native rights are to be granted by whom? Well, by white people in your court system, or the Euro-Christian court system. To avoid the color code, I use Euro-Christian. Why should it work that way for us? And I know you all are struggling and trying to do something useful and good. And there's part of me that wants to affirm that, but another part of me wants to say, wait a minute, why do we have to play in your ball game by your rules? Why can't you learn to play by our rules? And if you learn to play by our rules, we'll go outside here onto the prairie and we'll feel grandmother move beneath our feet. We'll relate to grandmother as that primal mother who generates all of life, and understand that there is no law that can make me the rightful owner of a piece of grandmother as property, whether it's a plant or a piece of acreage. Now we typically plant corn, beans, and squash, the three grandmothers, and we harvest them and eat them. But in our relationship with those grandmothers, we know that our planting has to be done in a respectful way. our harvesting has to be done in a respectful way. And before we eat those grandmothers, we have a long, long tradition of the grandmothers coming to us and giving us permission to feed ourselves on their fruits. We always take a little bit of that food and offer it back to all of our relatives and ancestors. I have a couple of drums, 2 noniompa pipes in my house, a couple of eagle wings and lots of eagle feathers. I offer that food back to them so that we can build our relationship with one another. In order to restore the harmony and balance that I necessarily violate every time I eat lunch, to put it bluntly. Yeah, we can't eat without disturbing the balance and harmony of the cosmos. That's the kind of relationship, whether it's relationship with Buffalo Nation or deer or elk or even cows, which are another invasive species in the Americas. They come from that colonial invasion. It's relationship that's important, not notions of ownership, not categories of prior art, not categories of who controls what, because we're all on the same plane with one another. I call our worldview collateral egalitarian, so that I'm not superior to this maple tree that's outside my window. I'm certainly not superior to the 3 grandmothers, corn, beans, and squash. I'm not superior to the Buffalo Nation, but we're all on the same plane with one another. And it's out of that worldview basis that I would say what my friend Glenn Morris is fond of saying in the Indian community here: there are no bosses in the Indian world, no leaders. We're all on the same plane. And yes, we turn to some elders for guidance. But once the elder has spoken, we're free to make our own decision. I'm considered an elder in this urban Indian community. Once I've spoken in a meeting, then I know my role is to shut up and let the young people decide what they're going to do, because I don't determine their course of action. That's a whole lot different from my daughter being in public school, where she knows the teacher's in control and is going to give her a grade. It's even different from my career, where I talk about these things in the classroom with a graduate seminar. We're all equal. And then I tell them, yeah, I know. The dean won't write me a paycheck at the end of the month if I don't give you a grade. Hierarchy moves right back into center stage, even as I try to diffuse hierarchy in my own classroom. That's the worldview out of which I'm speaking, and out of which Indian people speak. Why should we have to compromise that to create our own category of law? We'll give it a name. What will we call it? Oh yeah, Indian law. And there are libraries filled with Indian law texts. And yet I have to remind Indian lawyers, there is nothing Indian about Indian law. It was devised from the very beginning as a linguistic discourse to help the colonizer control Indian people, native people, and give them access to our land and everything else now. And the last thing people want is what they call our spirituality. They've now come for that. Kakuna.
Oh, thank you for that. And it makes me realize I wish we had several more hours today, which even wouldn't be enough to find ways, I think, to bring these worldviews closer. But I think only in having less than 15 left and maybe needing time for questions too, I'll try to find a way to maybe leave it to each of you to see how close perhaps we can bring these worldviews. And so I know, and maybe I'll move to you, Sutton, first for your thoughts on this. And hearing Dr. Tinker talk about relationship, and your own advocacy has really centered benefit sharing and being in the right relationship with Indigenous communities. And I wonder, sort of in your perspectives, if there are ways to balance, maybe ways that are being pursued now, the Indigenous worldview that Dr. Tinker describes, and sort of the patent system, and the more business-focused needs of companies in the psychedelic space. And sort of, what would be your thoughts on kind of bringing these together as close as they can be brought?
Sure. Well, I think, I just want to thank you again, Dr. Tinker, as an elder here, and everything that you have done to pave the way for someone like me, a young urban native, to continue the advocacy. I learned so much from you, and just really deep gratitude to you. I think what I would like to talk about is this kind of buzzword that's happening right now in the space around reciprocity, and would really want to and challenge folks in the space to stop using the word reciprocity, because there's this notion that there is this consent, this universal consent between Indigenous communities. And we just know that's not true, right? To move into a place of consent around our medicines, our ways of life, means that there's free, prior, and informed consent that's happening. Consultation is happening. Consent is not happening in the psychedelic renaissance. Folks are building these businesses. They are patenting these compounds, these botanicals, and they're taking them through FDA without any consent from Indigenous communities, traditional knowledge keepers, and that is really where we are today in this landscape. And so instead of using reciprocity, I would challenge folks to use the verbiage of access and benefit sharing, which comes from the Nagoya Protocol, right? And the Nagoya Protocol is really this multilateral legal framework that was set up with the international community, agreed upon in 1992, entered into force the year I was born, 1993. And it's really this agreement to ensure that there's a regulation of the access for users of type of resource that arises from genetic resources, really ensuring that they're sharing monetary and non-monetary benefits with its providers. And I would say there's about 196 signatories of this Nagoya Protocol. Unfortunately, the United States, who played a major role in drafting this, is not a signatory. No surprise there. However, that shouldn't stop us from really ensuring that these psychedelic drug development companies are looking at what I would call reparations. I know that's a very scary word for people to hear. We can say access and benefit sharing if it makes it easier for people to hold that. And I'd say an example of that would be Journey Collab, who has taken 10% of their founding equity and put that in an irrevocable trust. I think, what David has shared, there's a lot of challenges that are going to be arising around these patents, and as well as these signatory states, including Mexico, when we think about mushrooms and psilocybin, and these Indigenous traditional holders in these companies who are patenting these medicines, where we're going to see some very interesting legal cases around the Nagoya Protocol and access and benefit sharing. And I think it's in the best interest of these companies to go ahead and just engage in access and benefit sharing. I'm not saying that these companies should go and enact free, prior, and informed consent. I think there's an issue when we have a bunch of psychedelic drug development companies trying to go into Indigenous sacred spaces to extract further knowledge. I think there are vehicles like the Indigenous Medicine Conservation Fund, which is an Indigenous-led philanthropic vehicle, really shifting the paradigm on how we see philanthropy today, really putting Indigenous leaders in the seat at the table to make sure that the needs for the preservation of these biocultures are preserved. We know that these are keystone medicines. And when I say keystone, what I mean by that is that there is no substitute for our plant medicines. If our medicines are extinct and are not here today, biocultures that depend on them will fail, right? They won't thrive. They won't be able to survive without our medicines. And so how horrible would it be that in 50 years there would be synthetic mescaline, but there would be no peyote, right? We know there's an ecological threat to these medicines today. And so, you know, it really is the plight of Indigenous peoples who have stewarded these medicines, protected these medicines with our lives, so that you all could be here today to talk about patenting our medicines and trying to commodify them. And so I think it's really important that we think about how we can use these legal frameworks like the Nagoya Protocol, like CBD, to really think about how we can return the resources back to where they belong so that we continue to support Indigenous peoples who have the solutions for the issues that have been created by colonization, right? When we think about the world's biodiversity and knowing that 80% of it is protected by Indigenous peoples, I think that's a clear indicator that if we want to get into right relationship, if we want to achieve this balance and harmony that we are completely out of balance of, that we need to put Indigenous peoples at the forefront and listen. It's what my aunties always tell me, my Native aunties say, just listen, right? And so it's great that you all have included some Indigenous voices in this conversation, and would challenge you all to continue putting Indigenous voices at the forefront of these so-called psychedelic movements. I like to call them sacred plant medicines because they're not just compounds, they're our relatives. We talk with them, we pray with them. We see them all as, you know, our kin. So I just want to thank you. And again, thank you, Dr. Tinker, for all that you are and have done for our community and space.
Thank you, Sutton. Yeah, and I mean that's such a good maybe sanity check and even kind of a reminder that, you know, as far as we think we're going and having these discussions and people speaking about reciprocity, it just shows, I think, how much further there is really to go and how much more listening there is to do. So I'm hopeful that we played a small part perhaps in doing that, but you know, I feel like we've ended almost with a deeper gap between these worldviews, perhaps, but maybe a sight line between them that hopefully we can continue to sort of work on as we move forward. Listening to your keynote yesterday, Preeti, you encouraged people to join you in building a comprehensive agenda for patent reform and talking about ways to reshape the patent reform for the public and for everyone. And I wonder if you have reflections now, having sat in on this roundtable, if there's ways that, taking into consideration what you've heard here today, or Indigenous knowledge or Indigenous viewpoints, can be a part of that, or how to, I guess, think more about making it a part of that effort. And then I guess just generally, sorry to continue sort of your views on where you would perhaps find fitting the interaction between kind of what we've talked about and, you know, the patent system generally, or the intellectual property system.
Yeah, I think what's coming up for me is, so the way we've been working towards patent reform, it sort of draws from, I don't know if you all have heard Michelle Alexander speak, who wrote The New Jim Crow, but she has this like really beautiful line somewhere buried in the conclusion about how the change you seek or the reforms you seek are equally important, or maybe even less important than how you seek those reforms. So what's the process? And I think this is what Sutton's talking about, you know, who is consulted, who is at the table as an equal partner in the conversation. So that's what we've tried to start building. Our program is called Participatory Change Making. So it also has to do with this notion of proximity. You know, how often does a patent lawyer meet with someone who is advocating for diabetes medication? And how often do they meet someone who's a judge in the court? How often do they meet someone who's purchasing medication for people through hospital systems or through health services? So we've try to build this container where people are coming together and hearing each other's perspectives on how the patent system is working. And so I think what I'm taking away from today, though, is this notion of proximity is also what really stops the patent community, I think, whether that's at the USPTO or whether it's IP lawyers, I have some in my family, or pharma scientists, from understanding like a more expansive worldview and a deeper understanding of like the country that we're living in, the place that we're inhabiting, different values that I think will resonate, but people don't in this modern world stop to think about them and to connect the dots with the system that we're looking at. So I would love to look for opportunities and ways that, as Sutton was saying, you know, as you all in the community for, said Sacred Plants, Sutton, not Psychedelics community, Sacred Plants community, start to come together and have you know, more robust conversation with more people. I wonder if there's ways in the patent reform and access to medicines community more broadly, we can do the same so that people are hearing this wisdom. I think it'll be beautiful.
Thank you, Preeti. And David, I'm curious your thoughts too on ways that you think we can use the patent system, we can use what we have at Porta Sophia, and how your work can be used to sort of bridge these divides and kind of cut through this tension, or you know, you have reflections on you know, what the role of Porta Sophia or your role can be in doing that.
Yeah, and so I think this is a really useful conversation for us. We have multiple Porta Sophia members attending the talk, because I think most and possibly all of the work we can do can be non-intrusive. And we now know to use, and a number of people here have followed these topics, and you know, it's been an issue we've had. We're trying to give as much care to as possible, but you know, ultimately we're looking to keep well-being of all people as high as possible by preventing bad acts in the legal system, particularly the patent system. But I think the regulatory system also has a big role here, because it, you know, that's the system that will say you have to use a chemical synthetic and the naturals go away. And players in the system, both by intent, sometimes bad intent, and by accident or unintent, influence ways in which these two systems, the regulatory system and the patent intellectual property systems, say no. They limit access to people around the world for important compounds and important materials and preservation of materials. And at least where the bad players are and where the misinformed players are, the good news is, from at least what we've seen, it's a finite number of players whose actions can be stopped by a small group of activists and interested people who want to push back on that. And so I'd say everyone here who has an interest, this is not in its, I mean, there are some parts of this that are, you know, moving a boulder up a mountain, and they're not going to be able to be resisted completely. But in many fundamental ways, many of the worst harms can be stopped by individual actions by people on this conversation. For example, counteracting the bad acts of other individuals who are a finite number to prevent some of the worst stuff from happening, and to hold it back, and possibly to completely prevent it in some cases. So I encourage people to not be disillusioned by what seems like giant governmental systems and giant corporations, because when you look under the hood, it's a few small players who are causing some of the worst harm, and it just takes a few small good players to counteract it.
Well, I know we're at the hour, so maybe that's a good and a positive place for us to end. Maybe just because I know there were some questions we didn't get to, if people want to go around and say how people can reach out to you, and then we can maybe break there. And I'll thank you for everybody for having participated in this roundtable. There's so much more. I hope we can continue this conversation. I think maybe people will find ways to find all of you, or reach out to Porta Sofia or to Amanda. So I don't want to take up too much
I can
more.
certainly send out contact info to everyone who registered for the Zoom
Sure.
after the fact. That's all right with the folks on the panel.
Yeah. So thank you to everybody for joining us, and thank you, Dr. Tinker and Preeti, Sutton, David, for the honor of being able to moderate a conversation with you. I've learned so much myself, and really am hopeful to keep participating in discussions like this with all of you.
Yeah, thanks so much, Graham. Yeah, thanks to everybody. I'll give you the Zoom clap. Awesome conversation. And like I said in the chat, I hope this is kind of just maybe the beginning of something else that we kind of keep talking through. And so, yeah, thank you so much for your expertise. I know some folks have to dip, have a hard stop at the hour, so no worries there.
Makwa and Yako.
Thank you, Sutton. So yeah, I just wanted to mention, and again, this is in the chat, but our next kickoff session will be in just under a half an hour, and that'll be a kind of ask me anything, pretty low stakes, informal drop-in hour with the data team at Porta Sofia. And we're going to talk about, or the focus of that session will be about our third-party submissions. And if those are the means by which we directly intervene with the USPTO on individual patent applications to kind of present evidence that knocks out various claims and patent applications in a really granular way. If you can't make it to that session, we do have a portion of our website that has a bunch of press releases that talks about each of the third-party submissions that we've done. And that's fairly new, so do check that out if you can't make it. But hoping to see some more of you. And thanks again so much to everyone who was here and was engaged, and especially to our panelists and to Graham for moderating this wonderful conversation. So thank you.
Thank you all.
All right.
And I don't know if the link is going to stay live, but I'm